Next, we have two more concepts. First is priority of rights created by transfer. Like I told you, priority of rights is somewhat similar to this first come, first serve basis that we see in some webinar, workshop and all that stuff. It would be mentioned that it's a free workshop, but then we only have limited number of seats. We can only accommodate 100 people. So it's first come, first serve basis. Whoever is coming first, they will be allowed to join the workshop for free. But whoever is late, whoever comes after that 100, they will not be entitled to join it. Does not matter if they want to pay money or whatsoever, they are not entitled. That is basically whoever is coming first getting a right to enter. Similarly, we have this provision section 48, which is talking about priority of rights created by transfer. In case of transfer, what rights will be created? That is priority of rights. Whose right was created first? Okay, fine. There was transfer of property, but then whose right was created first? That is priority of rights. So where a person, so what is this main provision basically, right? Take for example, there is one specific property and we can take this same example. Take for example, there is this person who has this immovable property. Okay, so this girl is owner of this immovable property, and what she does is she creates this, she mortgages this property or she leases out this property to this person, and then again she will mortgage this property to this one. Like same property is concerned, but she is doing two different things with two different persons regarding the same property. In such a case, whose right will prevail? Because there is a maybe a lease created in favor of this person and there is rent agreement in favor of this person. Okay, so when one person transfers or alienates his property to some, like two persons or maybe more than two persons, same property is concerned, but same property only, this owner is transferring 2-3 times. In such case, what will happen? Who will get the right to enjoy the property? Because in case of lease also, the person would like to stay in the property, enjoy the property. Same would happen in case of rent also. So who will be allowed to enjoy the property? Who will be allowed to stay or reside in this property? In deciding this matter, court will apply the concept of priority of rights. Whose right was created prior, that person only will be having right to enjoy it. If this mortgage, this lease was created first, then court will say that this person is having priority of rights. His right was created before this rent agreement. So this person would be getting a valid right to enjoy the property. So it does not matter if it's like a lease agreement on the one side and it's a sale deed on the other side. Sale deed obviously is like superior, like you are giving absolute ownership. But even in such cases, right, we are going to consider priority of rights. We are not going to see how many rights were transferred or what was the amount involved in the transfer and other stuff, but rather we are going to see whose right was created first. That is nothing but the concept of priority of rights created by various types of transfers it may be. So section 41 is mainly based on this Latin maxim, que prior est tempore potior est jure. So it basically means one who is first in time is better in law. So whoever is first, whoever got the transfer done first, whoever got the right first, that person is having better, like better position or better title in terms of law. So law will give more importance to that person. Law would give a decision in favor of that person. But now there are certain essentials that we need to satisfy for section 48 to be applicable. Okay, so first thing is section 48 is applicable with regard to immovable property only. Okay, so section 41 is applicable with regard to immovable property only. First, the transferor transfers the rights in the same immovable property. That means it should not be like one floor someone is given on lease, another floor someone is given on rent. It has to be the same property. If it's one building, it has to be the same building. If it's one floor, it has to be the same floor. So the transferor transfers rights in the same immovable property. Whatever like small or big the property it is, it has to be exact same property only at different times. Transfer is with regard to same immovable property, but transfers are done at different times. One interest created should be prior in time and another should be subsequent. If we want to apply this concept of priority of rights, we always need to differentiate which one came first, which one came later. So it has to be that these transfers were done at different times and one was created first and one was created at a later stage, so that we can apply priority of rights. Such rights created cannot coexist and cannot be enjoyed in full extent together. Just because we are saying whoever comes first is better in eyes of law, that person should be treated like that. He should not be asked to share it with this other person, or it cannot be said that, okay, both of you are having right, these two rights should coexist, or cannot be enjoyed in full extent together. Like both of those persons would not enjoy it. Why? Because in eyes of law, anyways, whoever came first, that person is having like better position. Then each later right created is subject to the previously created right. So previously created right will prevail, but this one will not prevail. It will be subjected to that particular right. Okay, so if there is some problem with regard to the first right, maybe there was a condition imposed that, okay, fine, I'm creating this lease deed, but within 1 month you need to get the deed registered. If you are not doing it, this property would revert back to the owner. If those sort of condition was there, condition could not be fulfilled, lease got cancelled out, in such cases maybe the second one would be getting right, but it is always subject to previously created right. Previously created right would prevail. If not, then only second one's turn would come. Okay, so essentials, we have 4 things. First of all, it applies to immovable property, and the right should be created with regard to the same immovable property. Transfers has to take place at different times so that we can differentiate which one came first, which one came at a later stage. Such rights created cannot coexist or cannot be enjoyed in full extent together. Both the parties would not be enjoying the right together or sharing it, because anyways, whoever is coming first, that person is having better title. Last one is that the previous right, first right would prevail, later one would be subjected to this first one. Only if because of some reason first one gets cancelled out, second one may get an option, but otherwise not. Otherwise, we would say that whoever comes first in time is better in law. So there are these examples given in BAREC that X mortgages his property to Y for 90,000 rupees, and then he sells the property to Z. If we compare mortgage and sell, then sell is like absolute transfer. It's superior, right, in terms of alienation. But even in such cases, we would apply priority of rights. Here, 2 transfers have taken place. Now, Z owns the property. property was transferred to Z. He owns the property, but according to law, the property is still subject to mortgage, and in case of default of payment of loan, the mortgagee can cause the property to be sold, as the later transaction is subject to prior transfer. Even if the buyer is enjoying the property, residing on the property, and mortgagee has also not raised any objections with regard to it, but that does not mean that mortgage is no more existing. Mortgage is still there. If there is default in terms of clearing out the loan amount, mortgagee can still sell the property and get money out of that property. So whoever comes first, this mortgage was created first, that one will prevail. If the buyer wants to retain the property, he will have to clear out the property from mortgage. Okay, he needs to make that payment and he needs to clear it. Is this part clear?
Yes, madam.
So there are also concepts like what happens, right? Sometimes a property may be like under some mortgage. Okay, person has taken some amount of, take for example, there is one property, A is having a plot of land and he has already obtained a loan of maybe 12 lakhs rupees by mortgaging the property. By mortgage, okay, by way of mortgage, he has already obtained 12 lakhs rupees loan for that property. Now, when he has not cleared out that mortgage loan amount, right? During that stage only, he enters into like a rent agreement, the sale agreement, okay, sale deed with B. And he said that, okay, fine, I'm selling this property to you for 50 lakhs, okay. Now, once they were in the process of buying the property and all that stuff, B already like mentally planned, right, that I'm buying this property and stuff. Now, B after that came to know that this property is subject to mortgage and mortgage amount is 12 lakhs. Now, we need to consider that this amount is lesser in value as compared to this one, right? That means the original owner, the seller, he will be getting more money than the loan amount. Loan amount is smaller as compared to it. So in such cases, what B can do, right? B can go to court and he can file a case for specific relief. He can say that this person, this owner, we were already in the process of negotiation in terms of selling and buying the property for 50 lakhs, but this property is under some mortgage. So please ask this person that he is anyways getting 50 lakhs. So out of this 50 lakhs, he should take out 12 lakhs, clear out this mortgage, and after that transfer this property to you. So this is a very common sort of relief that people ask. It falls under specific relief, okay, that if this property is subject to some mortgage or any other thing where value involved is lesser as compared to what you will get under this sale transaction, then this person can ask that you clear out this mortgage and get it transferred to me. Okay, or he may even say that I'm not paying you 50 lakhs now, but I will pay you 50 lakhs minus 12 lakhs. I will pay you some 38 lakhs, get the property transferred. After that, I will clear out the mortgage. Those things also may apply. Okay, but this is not that relevant for this example. What is relevant is that some person mortgaged the property first, later on he sold the property. Who will be getting right under this provision, under priority of rights? Whoever came first. That means under this mortgage, the mortgagee would be getting that right. There was this case wherein court held that even if the documents of prior transfer are registered later on, he will still be given priority over subsequent transferee. This also holds true even when the later transfer did not have knowledge about the previous transaction. Even if the registration or completion of formalities took lot more time in the first transaction, that is still first transaction. That is still given priority. Like that one would basically prevail. Sometimes like for registration and all, persons need to apply, then some date would be given from the registrar office. On that date they need to go put their signature and all the formalities. So it may happen that in terms of priority of right, one was created first, but in terms of completion of formalities, the second one's formalities were completed previous, like first. Even in that case, we are considering this only as priority of rights because this one happened first. Similarly, there was another case, Hafiz Muhammad Anwar versus Jamuna Prasad Singh, where it was held that Section 48 of Transfer of Property Act 1882, if the same property has been transferred at different times, then subsequent transfer shall not confer any right or title or interest on the basis of subsequent transfer over prior transfer. So if there are two transfers done at different times, first one would prevail. Second transfer is not having any value. It is not creating any right, interest with regard to the property or title over the property. So first one would always prevail. That is priority of right, Section 48 of Transfer of Property Act.